Okay, good morning again, ladies and gentlemen. The next speaker doesn't need a lot of introduction. He'd be known to most of you. He's a great friend of this place and the work we do here. Has been with us on many panels, many difficult issues. He's been a good advisor from everyone's observations across the range of Indigenous affairs and Indigenous issues. He's the Aboriginal and Torres Strait Islands Social Justice Commission, and the speech today is going to focus on Indigenous property rights. Please welcome Mick Gooda.
Thank you, Sean, for that warm welcome to Gulkula country. It's wonderful to be here on the 40th anniversary of the Northern Territory Land Rights Act and another successful Garma festival. I'm a Gulkula man from central Queensland, and I acknowledge the elders here. I acknowledge Galarrwuy Yunupingu. I acknowledge his contemporaries. I acknowledge those who've passed before, and I also acknowledge the elders of the future, those young people who are yet to emerge. My dad was a ringer and a labourer who would turn his hands to all sorts of work to make sure his family survived and finally thrive. He was a proud unionist and advocate. I describe my mum as a lioness, a fierce matriarch and protector who was known to send shivers down the spine of anyone who she perceived as a risk to any of her children. Between them, they instilled in their children a deep sense of pride as Aboriginal people and a fierce determination to stand up for the less fortunate in those little central Queensland towns where we grew up. My dad heard of the fights of the Yolngu people, the fights they endured for their land and their culture. And from central Queensland, we heard of this warrior, Galarrwuy Yunupingu, this man who stood up to governments and stared down the prevailing orthodoxy of us being seen but not heard. As a young Aboriginal man starting to feel his way in life under the ever-present oppression of the Bjelke-Petersen government, Galarrwuy's award of Australian of the Year in 1978 was like a gift from heaven. Like the song about Muhammad Ali, Galarrwuy is our black Superman. I'm honoured to be standing here alongside such strong leaders of our people, and I can only imagine the pride of my mum and dad, what they would be experiencing seeing me on the stage with so many great leaders. Friends, the work of Galarrwuy, his elders and contemporaries, are legendary in Aboriginal history and the struggle for land. The drafting of the Bark Petition, which is now on permanent display in Parliament House in Canberra, is one of our best remembered and most beautiful efforts to engage with the Parliament of the day. Written in both Yolngu and English, it is a powerful symbol of our way of communicating, respect for both, inclusive of both. I wish I could say this inclusivity and respectful approach is always reciprocated. This week we have all witnessed the shocking treatment of our children here in the Northern Territory. We know it's not the first time, but it's the first time it has received national media attention and has been laid bare for all Australians to see, and Australia is shocked at the level of violence that us Aboriginal people almost take for granted. I've received hundreds of calls this week, emails and texts, expressing distress and outrage. People want to know how they can help. The people of this country and the world is watching us. Indigenous leaders spoke on Friday here about the need to shine a light on institutions like detention facilities, which by their natures are closed systems with closed cultures. What we have seen is, in part, the consequences of people feeling their conduct is not under scrutiny, not required to meet the standards, and that they will not be accountable for their actions. This must change. I was reminded in a Fairfax publication yesterday of Fyodor Dostoevsky, who said in 1862, the degree of civilisation in a society can be judged by entering its prisons. This week, we've entered one of our prisons, and what we saw not only questions our civilisation, but actually questions our humanity. I am hopeful that the Prime Minister's swift response will result in a positive change, but we must maintain momentum and we must remain vigilant. This Royal Commission must deliver more than a set of recommendations that remains on the shelf like so many reports of Royal Commissions and inquiries that have been done in the past. Real action is required to change outcomes for our young people. In the short term, I must say, we must ensure that those young men subject to that treatment must not be suffering any reprisals or recriminations. They also need access to care for the trauma they've suffered, and we need to know they are safe. Our children deserve better, and I am pleased that human rights standards are part of the terms of reference for this Royal Commission. Australia's human rights obligations that will come into play include the Convention on the Rights of the Child, the International Covenant on Civil and Political Rights, and the Convention Against Torture and Inhumane Treatment. These will set the benchmarks against which the actions of those in that centre will be judged. But critically, those human rights standards also include the Convention on the Elimination of All Forms of Racial Discrimination. The Royal Commission will have to confront the role race has played, not only in the action of those guards, but the fact that 97% of young people in that detention centre are Aboriginal, who would have to look at the underlying causes of how we've come to this point and confront the reality that race really does play a role. The recommendations of the Royal Commission into Aboriginal Deaths in Custody, the recommendations of the Bringing Them Home report, the recommendations of Little Children Are Sacred, all require that imprisonment is the option of last resort and set standards when detention is required. We need to give real effect to the fact that prison should be the option of last resort. And once people go into that prison, the decent treatment and ultimate aim of rehabilitation should be the focus. I will return to this matter before I finish here today. But as I reflect on these international human rights instruments from the beautiful country here, I reflect on the fact that the Bark Petition asserting Yolngu rights to land was delivered to the Australian Parliament 3 years before the United Nations adopted the foundational human rights conventions of the Convention on Civil and Political Rights, a Convention on Economic, Social and Cultural Rights, were not adopted until 3 years after the Bark Petition was handed to the Australian parliamentarians. The Declaration on the Rights of Development was not adopted till 1986, and of course the UN Declaration on the Rights of Indigenous People was not adopted in the General Assembly until 2007. And shamefully, 2 years later, it took 2 years for Australia to adopt that declaration. But in Yirrkala, Yolngu clans have been articulating their rights to land, sea, resources, language, arts, culture, both trade both domestic and internationally for generations. In 2011, the year after I took office as Social Justice Commissioner, I was privileged to be here at Garma when the representative of the Gumatj clan signed a memorandum of understanding with the Prime Minister of Timor-Leste to facilitate trade and other relationships. This year, the Garma Festival celebrates a milestone of the 40th anniversary of the recognition of Aboriginal people's rights to land. And for us, land, the fact that land is our backbone is more than a theme for this conference, it's our reality. It's a journey that began here with the Bark Petition, as I mentioned. Australia's first native title litigation known as the Gove case, which sparked the Woodward Royal Commission, leading to Aboriginal land rights in the Northern Territory in 1976. Today, approximately 47% of the land of the Northern Territory is Aboriginal freehold following a series of successful claims. The Act not only provides for these claims process strong tenure options and representative governance, it established land councils which have proved to be some of the most effective advocacy organisations we've ever seen in this country. The fight for land has taken many forms. The proposition for recognition of pre-existing rights to land that began with the Gove case found new ground with the late Eddie Mabo's case and subsequent Native Title Act in 1993. And while there are many Aboriginal and Torres Strait Islander nations yet to receive legal recognition to their lands and waters, we do hold legal rights to approximately 25% of Australia's land mass, and in addition to land councils and land trusts, 157 registered native title bodies corporates hold the rights to native title in this country. These are incredible achievements over the last 50 years, built on the sweat, blood and tears of our forebears and ancestors. In what is often referred to as this post-claim, post-determination phase, the question that I ask myself is this: where are the practical benefits from these long and hard-fought battles for the recognition of rights to land, water and sea? We've seen mining royalties come and go for some sections of our communities, and some groups have been able to invest and purchase businesses. But if we are to see real benefits from our land, sea and waters, we need to be able to exercise our right to development where we choose. So much of the conversation over the years has focused on protecting us from development, but we need to have a new conversation where we are able to be truly self-determining and properly engaged in matters that affect us. Self-determination, proper engagement, free, prior and informed consent, good faith, rights to protect our cultures are core to the exercise of our human rights set out in the United Nations Declaration on the Rights of Indigenous Peoples and other human rights standards. I listened intently to Gulkula speak yesterday about waking up the Land Rights Act, and I was really pleased to be sitting at the Gumatj Training Centre where your people, his people here are undertaking the development on their country. With these things in mind, the then Human Rights Commissioner Tim Wilson and I convened a round table on Indigenous property rights in Yawuru country in Broome in Western Australia in May 2015. Aboriginal and Torres Strait Islander land and native title holders attended the meeting along with Attorney General George Brandis. That meeting identified 5 issues that block economic development within the Indigenous estate and called for a national dialogue to find ways to address them. Significantly, the Attorney General agreed to support this dialogue and even challenging us as Indigenous peoples to develop the reform agenda for us rather than having reform imposed. The first issue raised in Broome was one of fungibility. Fungibility is the idea that property can be exchanged, bought or sold, and is one of the characteristics that allows it to be taken as security by banks or investors. Our interest in land generally comes from claim processes that recognise our collective deep connections to particular areas. The law describes our title as inalienable and community held. It's not readily sold or exchanged, and decisions about it must be made by the group. So when it comes to creating economic development opportunities on our country, the usual model where investors or lenders take security over land doesn't apply in the same way it might for land held by freehold. The second issue they identified was the need for business development and support and succession planning. They were clear that we need governance and risk management skills to successfully engage in business and manage our estates. The third issue identified was the need for financing economic development within the Indigenous estate, and the fourth issue was the ongoing and resolved one of compensation. I think compensation remains as unfinished business, important in its own right and as a means of leveraging economic development opportunities. Finally, the participants identified the promotion of Indigenous peoples' rights to development, promoting opportunities for development on Indigenous land, including options to provide greater access to resources on the Indigenous estate. Participants in Broome agreed that the Australian Human Rights Commission was the vehicle to progress this work. We began by creating an opt-in forum open to anyone with an interest in this work, which we call the Indigenous Property Rights Network. We've taken on board the concurrent and relatively recent work by the Council of Australian Government's investigation into Indigenous land administration and use, and the 2015 Australian Law Reform Commission's Native Title Inquiry titled Connection to Country, a review of the Native Title Act 1993, and the developing law in regard to native title compensation. We've also been mindful, as you have been here in Gulkula, about the government's Northern Development Agenda. We are very conscious that this holds both opportunities and challenges for Aboriginal people and Torres Strait Islanders who are keen to maintain their estate and to maximise economic development in accordance with the wishes of the traditional owners. This Northern Development Agenda will only be sustainable where Aboriginal and Torres Strait Islander peoples are provided with the opportunity to participate in the highest level of decision making, be partners in development, have the right to give or not give their free, prior, informed consent, and to benefit economically and socially from that development. At our first meeting in Sydney, network members developed a set of guiding principles which include the application of international human rights principles, in particular those set out in the UN Declaration on the Rights of Indigenous Peoples and the UN Declaration on the Rights to Development. This process will be Indigenous-led. It will be inclusive. We'll weigh on experience, advice, research, and what we produce will be based on evidence. It will promote self-determination. It will secure and protect the Indigenous estate. It will enforce our rights to make decisions. And the bottom line is respect for and protection of our culture. Since the Sydney Roundtable, we've held meetings in Canberra, on Minjerribah, North Stradbroke Island, for those who don't know, Darwin, and we will meet again this afternoon at the Garma Knowledge Centre. Once the Indigenous property rights reforms are finalised by the network, the next step is to advocate with government and industry for implementation. We've begun work with both groups to decide who will take this forward and the best strategy for progressing our work. So what are the reforms that people have raised with us? First, we need to map the Indigenous estate. We need to get a clear idea of the extent and nature of that estate. How can people exercise free, prior and informed consent and self-determination in relation to their land, seas and waters if they do not have a full sense of the extent and nature of their property? Mapping the Indigenous estate was quickly identified as one of the most important tasks to ensure traditional owners can make effective land use and economic development decisions. At the Commission, we undertook a desktop inventory of Commonwealth, state and territory statutes, regulations and case law that creates interest in land and waters for Indigenous peoples. One of the lessons we learned is that the holdings in land are continually changing, subject to parliamentary and judge-made law developments, planning, policies and land decisions. The National Native Title Tribunal has joined us at a number of roundtables to present their geospatial mapping work. They've developed a way to create an aggregated view of areas of land subject to the Native Title Act, as well as state and territory land rights legislation, Aboriginal lands trust schemes and other statutes created through specific acts or grants of land. This visual way of seeing the different kinds of tenure on a map is a really valuable tool, and I'm very excited about this work because I've seen it in practice with the development of the Quandamooka Atlas on Stradbroke Island. This atlas provides a visual representation of land, seas and waters subject to their rights and interests under a variety of land tenure and regulations, including native title, freehold, pastoral leases, local government zonings, and it was developed jointly between Quandamooka Yuli Yoruba Aboriginal Corporation and the Native Title Tribunal. The importance of mapping and recording the Indigenous estate is essential for traditional owners, but it's also essential that our rights to land, sea and waters are dealt with in a fair and transparent manner by states and territory land administration processes. Planning policies and laws can be particularly problematic for Indigenous landholders when decision makers assign land uses and restrict claimable land. We heard Joe Morrison yesterday remind us of the use of those things to obstruct the Kembe land claim many years ago. 37 years it took to resolve that one. A related and significant issue is the need for Indigenous interests to be recorded on estate and territory land registers. This is extremely important for ensuring that governments and private developers have notice of Indigenous interests on land and engage with us as rights holders in a timely manner when they are considering development proposals. Again, network members have raised the issue of respect for and protection of areas of particular heritage significance. In addition to these kinds of land administration processes, we've been consulting extremely wide with technical experts and land use owners about ways to create sustainable, potentially bankable tenure options. As I mentioned previously, the broader framework of barriers to economic development on Indigenous lands has a few different aspects. Firstly, native title is inalienable, so it cannot be sold or transferred in accordance with state and territory conveyancing legislation. And it cannot be subject to debt recovery process, so it cannot be used as security against a loan. Additionally, land right legislation limits the extent to which Indigenous land can be used as security for borrowing. Indigenous land is communally held, and this fact is often hailed as the death knell for economic development. But we feel that's not necessarily so. While it's true decision-making must follow particular rules, this approach is not entirely dissimilar to the kinds of decision-making processes for companies dealing with property where a board resolution would be generally required. To ensure sustainable land use, Indigenous Network and Strategy Group have been clear that reform options must not compromise our underlying rights to tenure. So we've remained focused on options which can increase the prospects for economic development without the permanent diminution of rights. Policy solutions are focused more on an interventionist approach by government rather than supporting Aboriginal and Torres Strait Islander peoples to manage their own affairs in locations they know well in accordance with their values and aspirations. The tendency to blame collectivism for limited economic development and insist on individual-based solutions requires review as well. There is no doubt that business needs innovators and a resilient entrepreneurial spirit to get going and to ride the ups and downs. But sustainable business ideas must also be adapted to the many and varied conditions across this country. At our last roundtable, we focused on building closer relationships between Aboriginal and Torres Strait Islander landholders and their representatives with the banking sector and Indigenous Business Australia. This sector is already engaged with many Indigenous business peoples and brings a wealth of experience and practical thinking to this work. To a large extent, these are fundamentally conversations about risk rather than land tenure or collectivism versus individuals. Both Indigenous peoples and financial institutions are considering the way they assess risk and developing new frameworks for business propositions. Financial institutions see value in exploring ways to lend for large and small projects without having to take a charge or mortgage on Indigenous interests, such as freehold parcels of land. Not least amongst the reasons they're looking at this is for the benefit of avoiding the potential embarrassment and reputational risk in selling the land of a prescribed body corporate or land council that might have been used to secure loans. Financial institutions are also realistic about the economies in rural and remote area where there is little or no secondary market from which to realise any capital from a distressed loan. Indigenous people are assessing their risk appetite, often for the first time, considering a new risk framework which balances their cultural responsibilities to past and future generations with the risks inherent in business ventures and the potential economic and social benefits when those ventures are successful. We've considered a number of other reform issues relating to incorporation options. We don't believe the only option for PBCs should be ORIC. We want to look at compensation, support for employment on country, support for post-determination litigation funding, support for comprehensive settlements, resourcing PBCs and supporting land councils, the importance of governance and business skills, and other issues. But I want to finish today by briefly talking about one of the priority issues in this process for me. As I said at the beginning of my time here today, we are really focused on opening up ways for Indigenous Australians to see benefit today and into the future from their struggles for land, water and sea rights. It is vital that this long process result in real, tangible benefits for Aboriginal and Torres Strait Islander peoples, improving their standard of living, enabling to live on and look after country. The issue of sharing the benefit of any successful economic development opportunities within the Indigenous estate is one of the least considered elements of the property rights discussion. That is, how do communities share in the wealth created from either acquisition of an interest in land or any economic activity carried out on that land? It's almost as if not much consideration goes into what will happen in the event of a particular claim or enterprise succeeding. The very purpose of pursuing claims or economic activity should be a successful outcome in which all those connected with the claim or activity tangibly improve their lives. The issue of good governance is central to ensuring that any benefit accrues to those with a right to benefit. It's essential that those with the right to participate in decisions around benefit sharing are central to the development of any benefit sharing regime, that benefits are shared equally between those peoples, and finally, all the processes around benefit sharing be open and transparent. We are in the process of developing a strong reform agenda guided by our Indigenous Network and Strategy Group. At the Canberra Round Table, it was decided there were three elements to the successful implementation of the property rights reform agenda. First, there was a need to be a meaningful relationship between those working on both property rights and economic development and the highest level of government. Secondly, the reform agenda has to be developed and well progressed within a range of ideas that have the security of the Indigenous estate at their heart. And finally, there needs to be a deliberate and well-organised advocacy campaign for the implementation of the reform agenda. It is imperative that any advocacy campaign be led by Aboriginal and Torres Strait Islander peoples, and we see a natural alignment of this advocacy group emerging from the Indigenous Strategy Group supported by the Indigenous Property Rights Network. Before I finish, I really need to return to what I said earlier. This is a terribly challenging time for Aboriginal and Torres Strait Islander peoples. The national media continues to report on the treatment of children and young men, and it's in our discussions at Garma here this week. As I said earlier, we need to support those young men depicted in the ABC's Four Corners program, their families and the support staff. We and they need to be assured they are safe, secure, and like I said earlier, protected from reprisals. The Royal Commission has a reporting date of 31 March 2017 and will be greatly assisted by extensive reporting, including Little Children Are Sacred, Bringing Them Home report, the reports of the Northern Territory Children's Commissioners, and the forthcoming report from the National Children's Commissioners consultation into juvenile detention centres. All of these provide descriptions, analysis and recommendations. And while we absolutely need to get to the truth of these events, there's a strong community sentiment that we already have long-standing, well-documented knowledge of this problem. We urgently need to move to solutions based on this inquiry, recent reports, international human rights standards, and the extensive work of the report of the Royal Commission into Aboriginal Deaths in Custody. A solutions-based approach is an engagement-based approach. Aboriginal and Torres Strait Islander people have been addressing, analysing, advocating on behalf of our children and young people for many years. We have set up support services and organisations to make a real difference on the ground. Aboriginal people understand these problems, and we have the answers. We are confident that the solution lies in more engagement rather than more money. The answer lies in a strong regional-based engagement with Aboriginal and Torres Strait Islander leaders of communities and organisations to set the priorities for those regions. Strong engagement by government with Aboriginal and Torres Strait Islanders on a region-by-region basis will deliver the advice and priorities for solutions. This requires more than consultation. It requires a resetting of a relationship to provide for a meaningful engagement where we are the decision makers in matters that impact on our lives. I want to finish with one more quote from that article in yesterday's paper. He said, "This sort of treatment can kill and coarsen the best man or woman to the level of a beast. Blood and power intoxicates in almost a foreboding prediction of what happened in the centre." He said, "Those who experience power and the unrestrained ability to humiliate another human being automatically loses their own sensation. Tyranny is a habit. It has its own organic life, and it finally develops into a disease. The habit can kill and coarsen the best man or woman to the level of a beast. Blood and power intoxicate. The return of human dignity, repentance and regeneration becomes almost impossible. Ladies and gentlemen, we can't let that happen." Thank you.
Mick, Gulkula missed the earlier part of your speech. I reckon it's worth repeating the family's moniker for him in the 80s.
Gulkula, we were talking about... I actually got interviewed when I got into this job. It's one of those interviews where you've got to pick 3 songs. I picked a Slim Dusty song for my dad. I picked Crazy by Patsy Cline for my mum. That was an indication. My thoughts about my mother. She just loved Patsy Cline. But for me, I picked Muhammad Ali's, the song called The Black Superman. And as a young man growing up in Brisbane, I shifted to Brisbane to work when I was about 17. And we were under the oppressive regime of Bjelke Peterson. He did ban street marches on a Friday afternoon occasionally. It was like the coming together in Brisbane CBD of 2 armies, one side the police, the other side protesters, and we were there. And to hear the song The Black Superman, Muhammad Ali, the Black Superman, just gave us a sense of pride as young people. And it was the days of disco and we'd all jump around in our flared jeans, dancing to the song. So my dad, Gulkula, heard of your fight up here for the country, how you didn't take a backward step. And as I said before, how you challenged the orthodoxy of Aboriginal and Torres Strait Islander people of being seen but not heard. And my dad was a great boxing trainer and student of the arts. And he said, I think Galarrwuy Yunupingu is our black Superman. So, dance like a butterfly, sting like a bee.